neutrality-related issues persist for UNRWA, and that there continue to be serious challenges with respect to UNRWA's oversight and accountability. Again, the Court need not and should not reach these factual issues. But given these concerns, it is clear that Israel has no obligation to permit UNRWA specifically to provide humanitarian assistance.
That participant claims that the Relief and Works Agency's privileges and immunities can be forfeited due to alleged neutrality violations. This proposition is legally unsustainable. In fact, the United Nations Secretary General is the competent authority to assess whether acts fall within the official functions of United Nations personnel and to determine whether immunity should be upheld. Moreover, the 1946 Convention provides that United Nations property and assets shall be immune from any form of interference, whether by executive, administrative, judicial, or legislative action. That protection is not conditional on the perceived behavior of staff members.
In light of the foregoing, Sudan concludes as follows. First, that the Court has jurisdiction to issue the requested advisory opinion and that no compelling reason exists to exercise its discretion to decline it. Second, that Israel, as an occupying power and a United Nations member, has obligation regarding the presence and activities of the United Nations, international organizations, and third states in the Occupied Palestinian Territory.
And I call Her Excellency Ambassador Umaima Al-Sharif to the podium. You have the floor, Madam.
Thank you. Mr. President, Madam Vice President, distinguished members of the Court, it is indeed an honor to appear before you today on behalf of the Republic of the Sudan. The government of the Republic of the Sudan acknowledges the importance of the advisory proceedings requested by the General Assembly Resolution number 79/323 concerning Israel's obligation in relation to the presence and activities of the United Nations, other international organizations, and third states in Occupied Palestinian Territory. Sudan addresses this distinguished court in the spirit of the UN Charter, guided by its purposes and principles, including the fundamental prohibition against the acquisition of territory by force. These principles resonate with urgency in light of developments that have obstructed the work of the UN Relief and Works Agency for Palestinian refugees in the Near East, the Relief and Works Agency, and the operations of third states in the Occupied Palestinian Territory, including East Jerusalem, as mandated by the UN General Assembly. We are deeply concerned by respective legislations imposed by the occupying state, Israel, that has effectively terminated the operations of the Relief and Works Agency in the Occupied Palestinian Territory, leading to the collapse of the severely needed UN humanitarian response. This outcome is deeply troubling and carries grave implications, not only for the humanitarian response, but also for the broader regime of UN privileges and immunities. Mr. President, the deteriorating conditions in the occupied Palestinian territory further diminish the already vanishing prospects for a peaceful, just, and durable resolution for the Palestinian question. The absence of a viable political horizon has led to catastrophic levels of suffering among the Palestinian people. There is now an urgent and compelling need for humanitarian relief. In these dire conditions, the Relief and Works Agency remains a vital lifeline for Palestinian refugees, particularly amidst the collapse of health and education systems and the destruction of essential infrastructure. Its work spans beyond Gaza to include the West Bank and neighboring countries such as Syria, Jordan, and Lebanon. Mr. President, Sudan recalls that the Relief and Work Agency, as a UN entity, symbolizes the international community's recognition of the plight of the Palestinian refugees and expresses a spirit of global solidarity. Since 1949, it has shown itself to be effective, efficient, and indispensable. There is at present no viable alternative to its operations, nor can its responsibilities be transferred until a comprehensive and lasting resolution of the Palestinian question is achieved. Mr. President, I respectfully ask that you grant the floor to Professor Raimondo, who will continue the presentation of our oral statement. Professor Raimondo will address three core elements. First, whether the court should render the requested advisory opinion. Second, the Israel's obligation to respect the sovereign rights of the State of Palestine to engage with third states and international organizations. And third, the Israel's obligation to respect the UN privileges and immunities. His remarks will be succinct yet comprehensive in outlining Sudan's position. Thank you, Mr. President. Thank you, distinguished members of the court.
I thank Ambassador Al-Sharif. I now invite Professor Fabian Raimondo to address the court.
Mr. President, members of the court, it is an honor to once again stand before this court to address the issues outlined by Ambassador Al-Sharif. Objections to the admissibility of requests for advisory opinions from the United Nations General Assembly are neither novel nor uncommon. Yet, the court has consistently and rightly dismissed such objections. I begin by recalling the court's jurisprudence on this matter, which forms the foundation for addressing the current objections. As stated in the court's advisory opinion of 19 July 2024, when a request is submitted, the court must determine, first, whether it has jurisdiction. And second, whether there exist compelling reasons to decline to exercise that jurisdiction. In the present proceedings, no participant has challenged the court's jurisdiction. Accordingly, I will not address this aspect and will proceed directly to the issue of admissibility. As noted in the 2024 advisory opinion, the existence of jurisdiction does not compel the court to exercise it in every instance. The court retains discretion to decline to render an opinion, but it has emphasized that it should do so only in the presence of compelling reasons. Israel and another participant raised 4 objections. First, that an advisory opinion would prejudge the ongoing contentious case between South Africa and Israel. Second, that the question presented is prejudicial and one-sided. Third, that the court has already addressed similar issues. And fourth, that rendering the opinion would require extensive factual investigations. The first objection is misplaced. The South Africa versus Israel case concerns alleged violations of the Genocide Convention, whereas the present proceedings concern distinct legal obligations relating to the conduct of an occupying power and its treatment of international actors. Moreover, advisory opinions are by their nature non-binding and serve to assist the requesting United Nations body in its functions. Therefore, the risk of prejudicing the contentious case is unfounded and does not meet the threshold of a compelling reason. With respect to the second objection, Sudan recalls that the court has the power to interpret and, where necessary, reformulate the questions put to it. It is for the court to assess the formulation, scope, and meaning of the questions submitted. Accordingly, this objection cannot stand. I now turn to the third objection, namely, the argument that the question before the court allegedly involves matters already dealt with in previous advisory opinions. Although the court has earlier found that Israel violated international law and has an obligation to end the occupation, the current request presents distinct and unresolved issues, especially considering the ongoing humanitarian crisis. It specifically examines Israel's duties as an occupying power and as a member of the United Nations, as well as the role and activities of the United Nations, other international organizations, and third states within and regarding the Occupied Palestinian Territory. In addition, the reference to the need to ensure and facilitate the unhindered provision of urgently needed supplies highlights the main focus, while also allowing the court to consider related legal obligations. there is no legal barrier preventing the court from giving an opinion in these circumstances, and the short time elapsed since the previous advisory proceedings does not constitute a valid reason to decline. Accordingly, Sudan submits that this objection should be rejected. I now turn to the fourth objection, namely that the court will need to make significant factual findings not suited to advisory proceedings. The court has already dismissed a similar argument in the previous advisory proceedings concerning the Occupied Palestinian Territory. It is well established that the court may rely on public information, including from United Nations organs and specialized agencies. In these proceedings, the court has before it extensive materials submitted by the Secretary General. It is for the court to assess the sufficiency of that information, and there appears to be enough to answer the General Assembly's question consistently with the judicial function of the court. Accordingly, Sudan submits that there is no basis for declining the request. Let me now turn to Israel's obligation to respect the sovereign prerogative of Palestine to establish and maintain relations with other states and international organizations, the United Nations among them. In its 2024 advisory opinion, the court confirmed that Israel, as the occupying power, must not obstruct the Palestinian people in exercising their right to self-determination, which includes the right to an independent and sovereign state across the entirety of the occupied Palestinian territory. As a core element of statehood, Palestine's right includes, and indeed requires, the capacity to participate in relations with other states and international organizations. This is not merely a technical attribute. Without the ability to engage internationally, statehood will be a hollow concept. Denial of this right strikes at the heart of what it means to be a sovereign people entitled to self-determination. Therefore, Palestine is entitled, through its recognized representatives, to develop and maintain relations with other states, the United Nations, and other international organizations. Conversely, other states, including Israel, are obliged to respect that right. This includes diplomatic and consular relations, engagement with international organizations, and the conclusion of treaties, among other sovereign rights. Where such relations are pursued freely by the Palestinian authorities, any effort to hinder them constitutes a breach of the right to self-determination. Likewise, deliberate efforts to obstruct the presence of diplomatic or consular actors in the occupied Palestinian territory infringe upon that right. I shall now turn briefly to Israel's obligation to respect the privileges and immunities of the United Nations. One participant in these proceedings presents 5 claims aimed at justifying Israel's actions regarding the Relief and Works Agency. Each of these claims is flawed in law and in principle. Sudan respectfully contests these claims, drawing upon the Charter of the United Nations, the 1946 Convention on the Privileges and Immunities of the United Nations, and settled United Nations practice. First, functional necessity. It is indeed true that Article 105 of the Charter of the United Nations refers to privileges and immunities, I quote, as are necessary, unquote, for the fulfillment of the purposes of the United Nations. But the interpretation of what is necessary is not left to the discretion of individual states. That interpretation was codified by the General Assembly in the 1946 Convention on the Privileges and Immunities of the United Nations, a treaty in force for Israel. That convention grants the United Nations absolute immunity from legal process unless it has expressly waived that immunity. It follows that the doctrine of functional necessity defines the scope of immunity, but it does not empower states to make unilateral determinations of when that scope has been exceeded. Second, alleged violations of neutrality. That participant claims that the Relief and Works Agency's privileges and immunities can be forfeited due to alleged neutrality violations. This proposition is legally unsustainable. In fact, the United Nations Secretary General is the competent authority to assess whether acts fall within the official functions of United Nations personnel and to determine whether immunity should be upheld. Moreover, the 1946 Convention provides that United Nations property and assets shall be immune from any form of interference, whether by executive, administrative, judicial, or legislative action. That protection is not conditional on the perceived behavior of staff members. Even in cases involving serious allegations, any recourse must be sought through United Nations channels, not through unilateral action that undermines the United Nations' independence and inviolability. This interpretation is confirmed by the Court's advisory opinion of 29 April 1999. Third, substitutability of the Relief and Works Agency. Whether other agencies could, in theory, fulfill the role of the Relief and Works Agency is irrelevant to the question at hand. The legal test is not about indispensability. The Relief and Works Agency is a subsidiary organ of the General Assembly and, as such, falls squarely within the protective scope of the 1946 Convention. Its privileges and immunities do not depend on how replaceable it may be. They derive from its institutional status. Moreover, the General Assembly has repeatedly reaffirmed the mandate of the Relief and Works Agency, most notably in Resolution 64/89 which calls on Israel to cease obstruction of the agency's operations in Gaza. Fourth, state party discretion. Israel cannot lawfully revoke or restrict immunities on its own initiative. The 1946 Convention confers absolute inviolability upon United Nations premises and archives. It further obliges states parties to actively protect these premises from interference, including by third parties. This inviolability includes immunity from physical searches of United Nations vehicles and materials, a point reaffirmed by the United Nations' own interpretation. Any obstruction of movement, searches, or disruption of operations, even if based on security justifications, must conform with Israel's duty of non-interference. Fifth, the Comey-Mitchell-Moore Agreement. That same participant invokes this bilateral agreement to justify Israel's actions. However, the hierarchy of norms under Article 103 of the Charter of the United Nations is clear. In case of conflict, obligations under the Charter prevail over any other international agreement. Furthermore, the Comey-Mitchell-Moore Agreement cannot displace the binding obligations under the 1946 Convention, which Israel accepted in full. As such, no bilateral understanding can lawfully be interpreted to override the core principles of inviolability, immunity, and independence. Mr. President, members of the Court, the framework established under Article 105 of the Charter of the United Nations, the 1946 Convention, and United Nations practice is clear and coherent. The privileges and immunities of the United Nations are not optional. They are not revocable based on allegations or political disagreements. They are the legal foundation that enables the United Nations and its agencies, including the Relief and Works Agency, to operate independently and effectively. Allegations of misconduct, if substantiated, must be addressed through the mechanisms of the United Nations itself. To permit states parties to the Convention to act unilaterally would be to undermine the very integrity of the international legal system and to erode the independence of the United Nations as a whole. Your Honours, I express my sincere gratitude for your attentive consideration. In times like this, when the authority of international institutions is questioned and the principles of international cooperation are at stake, we must confront the harsh reality that the pursuit of international justice is rarely straightforward, and that the ideals we uphold often face formidable challenges. Yet, it is precisely in these moments of trial that our unwavering commitment to the Charter of the United Nations and the fundamental principles of international law must not only endure, but strengthen. Mr. President, I respectfully invite you to request Ambassador Al-Sharif to deliver the concluding remarks of the oral statement on behalf of Sudan.
I thank Professor Raimundo. I now give the floor back to Her Excellency, Ambassador Umaima Al-Sharif. You have the floor, Madam.
Mr. President, distinguished members of the Court, in light of the foregoing, Sudan concludes as follows. First, that the Court has jurisdiction to issue the requested advisory opinion and that no compelling reason exists to exercise its discretion to decline it. Second, that Israel, as an occupying power and a United Nations member, has obligation regarding the presence and activities of the United Nations, international organizations, and third states in the Occupied Palestinian Territory, which include the obligation to respect the sovereign right of Palestine to enter into relations with other states and international organizations. And finally, that Israel is also bound to uphold the privileges and immunities of the United Nations and its entities, including the Relief and Works Agency, and that its recent actions constitute a serious breach of the 1946 Convention and the Charter of the United Nations. Thank you, Mr. President. Thank you, members of the Court, for your patient attention. Thanks also to the Registry and the staff of the Court for their continuous support.